Everything that is explained in this video is summarized from the CoinMarketCap news update on XRP. By the way, take a look at this. Revised deadlines set in the Ripple and the SEC legal battle, because important deadlines are drawing near. The protracted legal conflict that has been going on between the Securities and Exchange Commission, SEC, and Ripple is about to pick up momentum once more. Without question, the XRP community will be keeping a close eye on this particular case, and they will be hoping that the litigation, which has been a source of ongoing disruption to the XRP ecosystem, can be put in the past. Another showdown between the CC and Ripple is on the horizon. James Phelan, a former federal prosecutor, disclosed in a post on X, which was formerly known as Twitter, that the opening brief for the Securities and Exchange Commission is due on March 22. Ripple, on the other hand, will have until April 22 to file its rebuttal brief. As soon as that is finished, the CC will proceed to send its reply brief, with the deadline being set for May 6th. As Phelan pointed out, these days are included in the new schedule for the briefing on the remedies. For the opening brief to be submitted to the SEC was scheduled for March 13th. On the other hand, the commission submitted a request to Judge Analisa Torres, requesting extension of 1 week and stating good cause as the reason why the motion ought to be granted. After further consideration, Judge Torres granted the request. In addition, the Securities and Exchange Commission requested that the deadline for Ripple to submit its opposition brief be moved from April 12 to April 22. This would provide the defendants with the time to provide a response that is relevant to the brief submitted by the commission. Following the discovery stage, in which the regulator demands specific documents from the cryptocurrency company, this remedies briefing stage is set off from that first stage. The opening brief, which will be presented by the Securities and Exchange Commission, will center on these documents, which contain post-complaint institutional sales contract. As part of this document, the commission will also submit several demands concerning the remedies that ought to be given in its favor for Ripple's violation of securities regulations. In a prior ruling, Judge Torres had determined that the cryptocurrency company's institutional sales were considered investment contract. Here are some possible outcomes of the remedies briefing. In addition to imposing a monetary fine, the Securities and Exchange Commission C is anticipated to submit a request for an injunction that will prevent Ripple from engaging in institutional sales that violate securities regulations. Ripple, on the other hand, will almost certainly argue over the amount of the fine that the commission wants to contribute to the company. There's also the possibility that Ripple would argue that its offshore decentralized lending transactions do not qualify as securities. John Detton, a legal expert, had earlier recommended that the remedies briefing might not be as straightforward as it initially appeared, because it was possible that both parties would still be required to file additional briefs. Detton went on to say that he does not anticipate a decision being made until the latter part of the summer at the earliest. At the time when the verdict is finally handed out, there's also the possibility that any of the parties will file an appeal from the decision. New remedy submission deadlines have been authorized by the court, even though the cryptocurrency industry is still waiting for the gavel to drop and officially mark the conclusion of the prolonged legal standoff between the blockchain company, Ripple, and the United States Securities and Exchange Commission's commission. The revised timeline allows the SEC to file its opening brief by the 22nd of March. Ripple's objection is due on the 22nd of April, and the regulator's reply is due on the 6th of May, as stated by the court information that defense attorney James K. Phelan shared in his most recent update regarding the Ripple SE complaint on March 14th. To refresh your memory, in July of 2023, Judge Analisa Torres issued a ruling that stated that the sales of XRP by Ripple to regular buyers did not represent sales of securities, whereas the sales of XRP to institutional buyers were, in fact, sales of securities. As a result, the parties are currently attempting to reach a consensus over the amount of damages that Ripple is required to pay. Choices for you to consider the stock that is outperforming the market and making investors billions of dollars is the retail industry's unsung hero. 13 minutes ago, to enable integration with Pendle, Aerod's Finance has introduced the leveraged RT strategy vault. A minute and a half ago, what is the issue with gold and silver? And why does Robert Kiyosaki have such a strong preference for Bitcoin? Exactly 1 hour ago, 19 hours ago, Bitcoin Frontier Fund announced significant investments in the Bitcoin ecosystem. Take a look. Come along with us as we demonstrate the transformation brought about by cryptocurrencies one newsletter at a time. What are you waiting for? Sign up right away to receive daily news and market updates delivered directly to your inbox, along with our millions of other subscribers. Yes, millions of people adore us. The SEC request was granted. According to the information that was supplied by the former federal prosecutor at the time and reported by Finbold, the Securities and Exchange Commission had requested the aforementioned adjustment to the remedy briefing deadlines on February 27. This change included the agency's opening brief, the resistance from the blockchain business, and the SEC's response. In their explanation of the rationale behind this request for an extension, the legal team of the regulatory watchdog emphasized that it was the good cause under the federal rule of civil procedure. They also emphasized the sexiest care in completing remedies related discovery and briefing. In addition, the request stated that Ripple, which had already been granted an extension for the initial discovery date by Magistrate Judge Sarah Netburn, has consented to the petition submitted by the SEC. This is because the petition also implies that Ripple will have 9 additional days to submit its opening brief. The motion to modify the briefing schedule was submitted by the Securities and Exchange Commission on March 1, not long after that. Thielen added in the comments that the judge had granted the move. The SEC versus Ripple case will end when? At the same time, the cryptocurrency world is on the edge of its seats, carefully monitoring every RippleSec news piece and searching for hints as to when the SEC Ripple case will come to an end. It is possible that the case will not reach its conclusion before the year 2026 due to the possibility of appeals and the intricate legal struggle. The European Corporate Governance Institute recently published a paper in which they observed that the court found that XRP was not a security when sold to the public on an exchange, but it is when sold directly to institutional investors. This information has contributed to the misunderstanding that has been already present. Lawyer Bill Morgan made the following observation in response to this note, which was shared by XRP influencer Retta Kahneman. The token itself is never a security, but can be sold as part of a transaction or scheme that is a security investment contract. Morgan also pointed out that the statement was not the most helpful statement. Even among members of the XRP community, there are still some individuals who are being misled by this point. The ongoing legal battle between Ripple Labs Inc. and the Securities and Exchange Commission has resulted in the establishment of new deadlines for the submission of remedial briefings. In the lengthy court struggle that has attracted extensive attention inside the cryptocurrency industry and beyond, this new revelation marks a critical chapter in the ongoing conflict. The most recent timetable for the briefing on remedies, Attorney James K. Fallon, a notable figure who has been closely monitoring the RippleSec issue, has announced the altered schedule for the briefing on the remedies. According to the announcement that Fallon made on X, the Securities and Exchange Commission is scheduled to submit its opening brief by the 22nd of March, and Ripple is anticipated to file its opposing brief by the 22nd of April. Following that, the Securities and Exchange Commission will file its rebuttal brief by the deadline of May 6th. Following Ripple's pursuit of an extension for remedies-related discovery in February, the most recent modifications to the timelines have brought about the aforementioned extension.